do committee introductions. We'll greet the representatives from the Justice Action Group, excuse me. And I think that some remarks from Justice Mead will be distributed. And then we're going to take up our bills basically in the order presented. Yeah, we'll do them in the order listed, excuse me. So, which also is numeric order. So with that, Representative Caruso, would you like to start introductions?
I'd be happy to. Welcome, everyone. I'm Elizabeth Caruso. I represent House District 72, which is much of northern Somerset County.
Good afternoon. My name is Ellie Sato. I represent House District 109 in the beautiful town of Gorham.
Hi, I'm Adam Lee. I represent House District 89, which is downtown and New Auburn.
Good afternoon. I'm Jennifer Poirier. I represent House District 70, which is Skowhegan.
Welcome, everyone. My name is David Sinclair. I'm here for the people of House District 50, the city of Bath.
So, good afternoon, everyone. I'm Dylan Pugh. I represent House District 114, which is part of Portland.
Good afternoon. I'm Rachel Henderson. I represent the people of House District 78, which are the beautiful towns of Bethel, Byron, Hanover, Milton, Roxbury, and my hometown of Rumford.
Good afternoon. I'm Danny O'Halloran, and I'm proud to represent District 20, which is the industrious, or the majority of the industrious city of Brewer.
Also, good afternoon. Dave Hagan, Senate District 10, 12 towns surrounding Bangor, not Bangor.
Welcome. I'm Amy Kuhn. I represent House District 111 in the town of Falmouth, and I serve as the House Chair of the committee.
And my name's Ann Carney. I represent Senate District 29, so that includes South Portland, Cape Elizabeth, and some of Scarborough, and I serve as Senate Chair of the committee. And so committee members, as you probably all know, today is Access to Justice Day. It's an annual acknowledgement that the legislature has to express appreciation for the work that many of the legal services providers in our state do for Mainers, especially Mainers with low income who cannot afford an attorney in civil legal matters. And they're here today just to introduce themselves and to greet us and for us to express thanks to them. And so I think I would love to start by recognizing you, Justice Mead.
Thank you. Senator Carney, Representative Kuhn, and esteemed members of the Joint Committee on Judiciary, thank you for taking the time to talk with us today. During your introductions, I'm going to circle back around. I spent some of my youngest years in Rumford, and my wife is a teacher in Brewer, and I live in Bangor, so I've got some common ground here. I didn't realize we had these connections here. But great to be with you this afternoon. My name is Andrew Mead. I'm the Senior Associate Justice of the Maine Supreme Judicial Court. It's also my honor to serve as the chair of the Justice Action Group, JAG as we call it. JAG is a judge-led coalition of organizations and individuals committed to civil just access to justice. The members include state and federal judges, University of Maine School of Law, Maine Justice Foundation, the Maine State Bar Association, Maine Trial Lawyers Association, the Maine Civil Legal Services Fund Commission, practicing attorneys and others who are passionate about assisting all Maine people in obtaining justice in the civil matters. I had the pleasure of speaking with many of you this morning at caucus, and for those who weren't there, I'll just try and hit some high points. I know you have my written comments here. I also know you have a very busy afternoon ahead of you, so I'll try and be as brief as I can with the message that is actually very, very important. I've been a judge for 36 years now in the state courts, and I actually served as the judge of the tribal court for 10 years before that, so I've been a judge for 41 years. And during those years, I and all my judicial colleagues frequently experienced the tragic circumstances in court when people came to court absolutely unable to secure counsel. They live at the bottom economic rungs of the economic ladder, or they have a disability or some condition that really prevents them from operating effectively. They come to court, they're fearful, they are intimidated, they're sometimes aggressive because they're not sure what to do. They make mistakes regarding their cases, and these are important cases. These are life-changing and sometimes life-threatening situations. And as you've heard me say before, the lawyer who represents them has the job to represent them, to represent their client, and not to take into consideration the other party. I, as a judge, am a referee. I don't get to step in and help anybody present their case. So we watched this take place, and it is so hard to watch. That's really why I'm here today and why I'm the chair of the Justice Action Group. Civil legal services providers step in for these folks. They provide representation, and an interesting thing occurs. If people don't have lawyers when they come to court, and if the case goes against them, they thought they had a righteous position coming through the door, and they lost. And the only conclusion they seem to be able to come away with is, this system's broken. This system doesn't work for me. They become alienated, hostile. And at this time in our nation's history, we really can't afford any more alienated, marginalized people. When people come to court with a lawyer and the case is tried and they lose, they can accept it because they know they were heard. They know they had the assistance of somebody who knew their way around the complicated area of the law. Sadly, the vast majority, as you probably know, are coming to court without a lawyer these days. The civil legal services people who are represented here today step in those circumstances. They provide terrific representation in these very difficult cases. And also, we have to thank the members of the bar, the lawyers who contribute their time generously, including your chair, Senator Carney. But the need is great, and the resources there don't even come close to matching it. There's something called the justice gap. There are numbers we can talk about if you want to hear about it later. We're not even close. So the key element we're talking about here is funding to cover these things. The providers are actually on the precipice of a cliff at this point here. We can talk more about that if you wish. But the funding is absolutely critical, or these services are going to be seriously dialed back. Everyone here, we all believe in access to justice and justice for all. I think that's why we're all here today, because we believe everyone is entitled to the protection of the law. The civil legal services providers provide a vital role in that. I think outside this room, a lot of people don't understand the distinction between the criminal crisis, where there aren't enough lawyers for the criminal cases, and the civil cases, where there aren't enough lawyers. Civil legal services providers fill that gap. So again, I'll commend my written statements to you, but I'll just briefly wrap up and say that access to justice and justice for all is that aspirational goal, but we need to do everything we can to reach that aspirational goal. And I'm available if you have any questions, comments, complaints, or anything else.
Thank you very much. I want to give Representative Babin an opportunity to introduce himself. You may also have a connection with him.
Probably with hitting 500, so.
Good afternoon. My name is Mark Babin. I am the House Chair.
Oh, nice to meet you. Promotion.
Amen. District 3, Northeast Aroostook County. Thank you.
Okay. Well, I love Northeast Aroostook County. Hand him the gavel. I was just up there all the time. I was my law firm's representative in Aroostook County, and went all the way up to Fort Kent and Fraser Paper Company. And I know the folks up there, they're wonderful people. So.
Thank you, Justice Mead. Really appreciate you being with us
Thank you
today,
so much for your
all
time.
morning, actually, in the legislature.
Appreciate the time.
Thank you. Would any other of the civil legal services providers wish to address the committee, or are you?
We'd love to
Okay.
talk, but we hadn't prepared an additional presentation.
Okay, I wasn't expecting you to, but I just wanted to make the offer. I don't know if committee members have any questions. Anybody have questions? Just appreciative. Thank you. Well, maybe we should express that with a round of applause and say thank you for all your work. Many thanks. Okay, so we're gonna start our first work session. This is a work session on LD 208, an act to eliminate the 72-hour waiting period on firearm purchases. This is Representative Fockingham's bill, and did he ask to be notified?
I did not.
You did not? Okay. You could just call down. But in the meantime, Eli, could you please orient us to where we are?
Good afternoon, Eli Murphy, Office of Policy and Legal Analysis. Folks will remember at the end of last session, this bill, the conversations where we left this bill off was that it was going to be tabled and carried over. This bill, as well as the next bill that we were going to discuss, are currently the focus of litigation that is before the First Circuit. The intention of the carrying over and holding off on this bill was to try and give time for that First Circuit to act upon the case before them. It is now the end of the second regular session of the 132nd legislature. The First Circuit has not yet acted, and so it is back before this committee for presumably a final resolution.
Thank you. And just to remind committee members, this is the last day that we're authorized to do work sessions in this legislature, actually. So let's see, do any committee members have questions for Eli? And I'll start with a question for you, Eli, which is, have you recently checked the First Circuit website to see if there is any indication that there's been a resolution?
I have not. I got in the habit of checking fairly frequently. I've not checked in the past week. However, I do also get pushed to my email when there are new orders or new opinions issued by the First Circuit. I've not received any as of 20 minutes ago.
Okay, thank you. Any other questions for Eli? Yes, Representative Kuhn.
Thank you. So we carried over this bill because it's currently pending in court. We are still in the same situation. And it seems to me to still be premature to weigh in on this measure while it is before the courts. And so what I would propose is a resolve to direct the Attorney General to monitor the case in the First Circuit and report back to the Judiciary Committee and the presiding officers by a date certain. And Eli, I guess I would appreciate your help on that. If that date should be before the new legislature is sworn in, or would that be, a January 15th date like we might see?
I think likely that date should be, January 15th or something after that next legislature and this next version of the Judiciary Committee is seated. There's not a whole lot that is going on, especially in this interim, in these buildings in the months before that new legislature is seated. Presumably all of you will want to be out campaigning and dealing with things November related. So I can't imagine anyone would be here but for myself to receive anything prior to January 15th or so.
Okay, my thinking was whether someone would want to put a bill in before cloture. That was one thing I was thinking, but I would imagine if we got a ruling from the First Circuit, the Ledge Council would consider that an emergency as an after deadline bill in any case.
Yeah, I mean, I guess my thought process in that is simply just if they were to, if the resolve was to require them to report back to the Judiciary Committee, I'm not sure what that would look like absent the committee coming in.
Mm-hmm.
Yeah.
Okay, that makes sense.
Representative Poirier?
Thank you, Madam Chair. My feeling with this bill, regardless of the court case, is that we have Second Amendment rights. And barring anything that a person may have done illegal to prevent them from carrying a firearm, I don't believe those rights should be delayed. So I'm prepared to move ought to pass on this.
Okay, there's an ought to pass motion and seconded by Senator Hagan. Is there any discussion, committee members? Representative Lee?
For those who were around for the 131st, they'll remember that I had one of my Lee reports that only I joined on the 72-hour waiting period bill, but ultimately voted for the bill when it hit the floor, because I do think that there are some excellent measures in a 72-hour waiting period that can resolve issues for those who commit suicide with a firearm. And so I was ultimately supportive of it when it hit the floor. There are certainly some changes that I would still like to see in the bill. And certainly if the Beckwith case comes back and says that this component of the statute is unconstitutional, I would want to amend it to remedy it. And do what we can with it. If they say the whole thing's unconstitutional, I think it would also make sense for us to come back and repeal it. So for those reasons that I would still like to see some reforms to it, and I would, to resolve the issue of not coming back until the next legislature, if I were elected to come back, I'd probably put in a placeholder bill that would have some of those reforms that I'd want to see made anyway. And if Beckwith happens in that period of time, then that could be the vehicle that could be used for doing that. So I'll be supporting the resolution.
Anybody else have thoughts they want to share? And Eli, is there any fiscal note on this?
There would not be.
Okay, thank you.
I haven't received any preliminary fiscal note, but my assumption would be minimal, if anything. I think that if I remember rightly, the fiscal note on the other end was something along the lines of potential minor cost increase for number of cases filed within the court, something like that. Kind of the generic, this may add a couple of cases to the court system.
Okay, that was my assumption
Yeah.
as well, but thank you for checking that. Anything else, committee members? Representative Henderson.
Thank you, Madam Chair. I would just say I was comfortable weighing in and debating this and discussing this before it hit the courts. I'm comfortable weighing in, discussing it while it's sitting within the courts. I know where my position is on it, regardless of the final disposition of the First Circuit. A right delayed is a right denied. And we currently have laws on the books here in Maine where somebody can legally in Maine through a physician commit suicide. And to say that somehow that this bill is put in place to help prevent that, I understand the testimony that came in front of us. And I hear the heartbeat of the people who've lost loved ones, but I'm not seeing how this at all is helping prevent suicide in any meaningful way, especially considering that we only have one confirmed case in the state in years of someone who has purchased a firearm and then in the first 72 hours used that firearm to harm themselves. So I'm happy to vote in favor of the bill today.
Any other discussion, committee members? Seeing none, is the committee ready for a vote? It appears that we are. Thank you, Clerk Panet.
Thank you, Madam Chair. Senator Carney.
No.
Senator Carney votes no. Representative Kuhn.
No.
Representative Kuhn votes no. Senator Hagan.
Yes.
Senator Hagan votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Sinclair.
No.
Representative Sinclair votes no. Representative Pugh.
No.
Representative Pugh votes no. Representative Henderson.
Yes.
Representative Henderson votes yes. Representative O'Halloran.
No.
Representative O'Halloran votes no. Senator Talbot Ross. Representative Lee.
No.
Representative Lee votes no. Representative Sato.
No.
Representative Sato votes no. Representative Babin.
Yes.
Representative Babin votes yes. Representative Caruso.
Yes.
Representative Caruso votes yes. Representative Dana. I'll recall the absentees. Senator Talbot Ross. Senator Talbot Ross is absent. Representative Dana. Representative Dana is absent. Madam Chair, I have 5 members voting in the affirmative, 7 members voting in the negative, 2 members are absent, and that is the vote of the committee.
Thank you. And Representative Kuhn, I'll turn to you to articulate your report.
So this would be an ought to pass as amended with a strike and replace, turning the act into a resolve, directing the Attorney General to monitor the Beckworth case and report back to the Judiciary Committee and the presiding officers regarding the court's findings by January 15th, 2027.
Okay, and let's go around for those who voted no, if you can, are you in favor of that report? And I am as well. Okay. And Representative Sinclair, you are as well. Yes, okay. Right, so we'll end the work session on LD 208. And we're going to open up our next work session. And this is LD 1230, an act to abolish the 72-hour waiting period for a gun purchase. And this is presented by Representative Chapman, and I understand that he's not able to be with us today. Do you have any update, Representative?
He was going to try to be here, but he had an appointment at the VA, which he just isn't able to reschedule that. So
Did you know if he asked for a link and if he's available online or
he's in an appointment. So
he's
I,
lit it
Yeah.
right actively? Okay.
yeah.
Okay,
so
thank you.
I think we're safe to move on without him.
Okay. Eli, we'll just let you orient us when you're ready, please.
Sure. LD 1230, as Senator Carney stated, is an act to abolish the 72-hour waiting period for a gun purchase. The procedural posture of this LD is the same as LD 2208. With the one caveat that you will remember, I think on Friday, I believe an email went out. I believe that a proposed amendment will be offered by the sponsor. I know that we just discussed the sponsor is not here, so I might defer to Representative Poirier to present that or give that if you want.
It's pretty self-explanatory.
Representative Poirier, would you like to go ahead and present the amendment?
Sure, I'll let Eli get it out. Do you want me to start now or wait till everybody?
Please wait till it's distributed. I think that'll be easier for everyone. And I think everybody has a copy of the document. Representative Poirier, go ahead.
Sure. Thank you, Madam Chair. So what Representative Chapman's bill does strikes and replaces the entire bill, changes the title and such. And what this bill does is repeals the new Extreme Risk Protection Order Act. And I say new because yellow flag and red flag in statute are named very similarly. This is a repeal of the new red flag.
So of the legislation that was passed by the voters in November.
Correct. That hasn't been used yet. Imagine that.
Eli?
And to walk you through the language that is in front of you, because all it says is a bunch of it's repealed. Section 1 of this 6-section amendment, or I guess we'll start with section 6. Section 6 is repealing the chapter of law that was enacted that is commonly known as the red flag law. Sections 3 and 4 are just grammatical fixes. Section 5 is a place where that chapter is referenced in the warrantless arrest chapter of our laws. Section 1 is where it is referenced in the possession of firearms prohibited section of our laws, and then section 2 is where it's referenced in the bail statute. And so though it is a 6-section amendment you have in front of you, the meat of what the sponsor's intention is that section 6, sections 1 through 5 are just getting rid of places where it's referenced.
Thank you. Any questions for Eli committee members? Seeing none, any committee discussion? Representative Kuhn?
Yeah, I'll just flag that I have concerns about this because it's an entirely new bill that has not been subject to a public hearing. There was never a request for a public hearing. We are past the time to have public hearings. And we've been pretty consistent in our committee practice we just had one last week requiring public hearings for new bill content. So I'm just sharing that with the committee that I feel concerned about that moving forward.
Anybody else wish to speak? Yes, Representative Porter.
Thank you, Madam Chair. And I will just say, when it comes to red flag, I fought very hard to have a public hearing on that. And I think we heard from a lot of people regarding that. And I don't think that would be necessary here. It's regarding red flag, which we did have a public hearing on.
Thank you. Representative Kuhn?
So I would just say that this would be a repeal after an overwhelming vote of across the state of people saying they wanted that put into law. And so if there was a repeal, I think the public testimony we would get would be very different because it would have to do with overturning the will of the people in addition to the merits of the bill. And that, I think that is a different public hearing.
Anybody else wish to be heard? Representative O'Halloran and then, Representative Lee and then O'Halloran.
I don't know. I don't mean this to come off preachy, but I get really frustrated with the unnuanced way that we discuss firearms bills. We're really capable of digging in and doing nuanced work on complicated policy, except for firearms bill policy. I'll be candid. I don't like the bill that came out of the referendum because I don't think it has a lot of the due process protections that we had worked as a committee to add back in. I think there are probably several reforms that I would have done to the bill that was approved by the voters, but I can't ignore the fact that the voters approved by 63% the referendum. That includes 65% of people in the city of Auburn that I represent and the sponsor of this bill represents. And I mean, we haven't had a public hearing on any of the nuanced components of the bill or any of the reforms of the bill. The bill sponsor lives 2 miles away from me, could have probably discussed some of the reforms that I would want to see in a bill like that. And we could have put in a bipartisan bill to ledge council to maybe fix some of the components of what the voters approved by 63%. But I can't ignore that the voters approved it by 63%. And I don't think we should ignore that the voters approved it by 63%. And I'll be voting against this very large amendment that has received no public hearing.
I appreciate you saying that, Adam, because I agree with that a lot myself. To me, there's a big difference between people who are at the end stage of life and suffering extreme pain or debilitating diseases. And even though I'm not a supporter of this bill as it is currently written myself, I just cannot in good conscience override the will of the people, especially for something that's hardly taken effect yet. And there are Democrats, Republicans, and independents in my district that did vote for this red flag law. And so I feel like I have to respect that as well.
Any other discussion? Representative Porter?
Thank you, Madam Chair. I think the committee knows how I feel about this bill because I've talked about it at length in previous discussions. It is true 63% of voters did vote for this, but it's also true only 47% of registered voters actually voted in that election. So I think to just say 63% of Mainers supported is a little skewed. I also have a lot of conversations with law enforcement, and I have since the red flag law has been put into place, which is proving one to be very costly to mean taxpayers of how this whole thing is going to be implemented, but also the law enforcement officers that I speak with when anybody they're helping out asks them about extreme risk protection orders, they're telling them go with yellow flag because it's proven to work and it's safe. they still have very, very strong concerns about the safety of citizens and officers if or when a red flag is issued. It hasn't been used yet. And I don't feel comfortable whether 63% of voters have said we want this or not, putting law officers' lives on the line to go in and take somebody's firearms unannounced. So with that, I move on to pass.
Ought to pass, not ought to. Okay, thank you. Is there a second? Seconded by Representative Hagan. Is there discussion on the motion? Actually, would like to share how I feel about this. I feel very strongly that taking up this amendment is contrary to the process and practice that this committee has followed this entire legislature. And we're basically repealing a law that 63% of those who chose to exercise their right to vote voted for, and we are not giving them a chance to be heard. And had we had this proposal any earlier, this proposed amendment, I would absolutely have required us to have a public hearing. And we find ourselves on the last day that we're meeting as a committee to do work sessions, and with reluctance, I would say that I think I'm procedurally willing to let this proposal be considered. And so I won't rule it out of order, but I do think that it does go contrary to the careful work we've done together all session. Representative Hagan, Senator Hagan, excuse me.
Well, I like that term better, believe it or not. I have concerns for law enforcement. I see law enforcement almost on a daily basis. They really, really, really did not want this. Yellow flag has turned into an excellent tool for them to be able to safely take a terrible situation under complete control, and also provide mental health care for those who are in a lot of need. And I speak with a lot of them, and they do not like red flag. Yellow flag is something that's evolved into an excellent law enforcement and mental health tool. Red flag will put lives on the line. And of course, it's in the courts because of the constitutional amendment infringing nature of certain parts of it. So that's all I have to say.
Can you clarify that are you saying that there's a court action regarding the legislation that the voters passed?
No, it was what we talked about earlier.
The 72-hour?
Yeah,
Okay.
I guess I was a little off, but red flag, I'm absolutely with law enforcement on that. The ones that I've spoken with, and certainly haven't spoken with them all. So thank you for that correction.
Yeah. And I would just respond briefly that, one of our roles is to review the reports of the Deadly Force Review Panel. And every time I read one of those reports, I fear for the police officers involved in those confrontations, as well as the people who are injured or killed, as well as the police officers. And I think that the vote of the public on the red flag initiated bill indicates that although law enforcement may in some instances prefer the yellow flag, that family members who are worried for the safety of their loved ones would like to have this process. And so I will be voting against the motion. Representative O'Halloran.
I appreciate Dave's comments, and I've encountered some law enforcement that feel the way he stated, and I've found some that don't. And, I myself, along with many other people, thank God for law enforcement every day and pray for their safety. And And, you know, I come from a long line of law enforcement families. But the fact is that we have standoffs and we have lots of really dangerous positions that law enforcement is finding themselves in on a regular basis. And, you know, I guess and I'm hoping, and I'm thankful for the yellow flag law because it has been working very well. But I'm hoping if there is even a chance that this red flag law can come somehow law enforcement can be interjected sooner before it leads to situations or standoffs, because they're still going to be going to those calls. If they're escalating and there's guns involved, law enforcement is going to be there, whether there's a red flag, yellow flag, or no flag law. So I guess I'm waiting to see how this plays out, and I'm hopeful that this will be another tool possibly to prevent those standoff situations and putting law enforcement and the general public that needs their help in jeopardy of losing their lives.
Thank you, Representative. Any other discussion, committee members? Representative Caruso.
Thank you, and I appreciate everyone's sentiments, and I just want to say that I do support this motion simply because I don't believe that sitting here in this horseshoe that we should be determining, or this House should be determining how all of our law enforcement does their job and feels safe. And when the different organizations from the state police and the law enforcement unions and all of their groups came out and said that it endangered them, it was not what they wanted to do, I don't believe that I can support something that endangers our law enforcement. And I do also, I know that the yellow flag is working, it has been implemented, and I'm glad that we have that. It's sad that it wasn't followed through as it should have and prevented the Lewiston disaster, but now they fixed it, they're following it, they're using it. So I'm glad that there is that level of defense and help for people.
I just want to remind committee members that there's nothing about the original bill proposal or this proposed amendment that addresses the yellow flag. And so I would ask you to keep your remarks focused on the proposed amendment itself. Representative Kuhn.
Thank you. I understand that you've made a ruling about the necessity of a public hearing, so I'm not challenging that, but I continue to feel very frustrated by this, that we are basically taking testimony by proxy from law enforcement and no one else. Because there are a lot of people who would be very upset, not just about the underlying law, but the process, that we would come in less than a month after this law has gone into effect and overturn the will of the people in this manner is really shocking to me. So I understand there's been a ruling, and I guess, one way to look at it is that, the ultimate public hearing is a statewide referendum where every Mainer has an opportunity to weigh in, and they let us know what their views are. And I just think this is an inappropriate method to undo their votes.
And I would say I agree with you, particularly because we have heard that testimony by proxy, but we haven't actually let the public know that they would have an opportunity to testify as to whether we should repeal a new law that was adopted by the voters less than 5 months ago. That being said, committee members, are we ready for a vote? Representative Henderson.
Thank you, Madam Chair. And I would have to agree with Representative Lee in one of his statements, at least, when he said that it feels like when it comes to firearm bills that we all just kind of scurry off. You didn't say this, but I'll paraphrase for you.
And if you can just keep it to the amendment language, please. The debate on the motion.
Yes. It's my understanding that there's been conversation thus far by yourself, by both chairs, by Representative Lee, that were allowed, that were in reference to not just the amendment at hand, but the process itself. So I presume that I'll be permitted to do
fine.
that.
Yes. Yep.
Thank you. That at times with firearm discussions that we don't always believe the best intent of each other, that we come in kind of already predisposition on how we're going to vote. And I would furthermore say, as someone who tries to objectively look at things in the process and uphold the process as well, that I do tend to agree with the chairs in the fact that this feels like a last minute amendment with no public hearing. I know we've had a public hearing on the original red flag law, but that it does somewhat feel a little last minute. So I think internally, as I'm trying to like make sense of how I move forward with this, I do want to recognize both the chairs and say, I don't disagree with you. But also the amendment makers and those of us who discuss these bills, we're not responsible for the scheduling of this bill either. So these bills were scheduled on the last day that we are permitted to have work sessions, and public hearings can't be held anymore. So when a bill comes before us, that's when we take action on the bill. And the bill, this is the first time this second session that the bills come before us on the very last day that we can have committee. So I would just offer that.
Yeah, I appreciate that. I would just respond that you'll see in the upper right-hand corner of the bill, the date is 3/13/26. And if I recall, this came very much at the end of that Friday. That Friday was the deadline for voting bills. If the sponsor had, if the sponsor had proposed this amendment or let us even know that he was considering this amendment sometime before like 4 o'clock on the last day that we were authorized to vote on bills before we got the extension, then we definitely would have scheduled it for a public hearing, probably in February, if not early March. And there is the fact that this came so late and on, I mean, we've all had notice all session of when the last day for voting on bills, when that deadline was. And we've all been operating under that same assumption. And so it does very much concern me that the sponsor waited until the end of that day to propose this amendment. And, you know, again, as I said, I don't think it's proper, based on everything we've done this session to take this up, but I do feel that it is better for us to vote on it and to send the bill on its way rather than to rule it out of order. And so I would like us to move forward with a vote when everyone is done discussing it.
I would like a caucus, please.
Okay. Committee members, if everybody can take your seats, we're going to move on. And just as a public service announcement, the plan is we're going to move on to a vote on this legislation. Then we'll do some language reviews and then we'll take up our last work session of the legislative session. Is the committee ready for a vote? Yes,
I apologize. I've forgotten what motion's on the floor.
thank you. It said ought to pass as amended, reference the yellow amendment proposed by the sponsor. And it was moved by Representative Poirier, seconded by Senator Hagan. Is the committee ready for the vote? It appears that we are. Clerk Burnett, thank you.
You, Madam Chair. Senator Carney.
No.
Senator Carney votes no. Representative Kuhn.
No.
Representative Kuhn votes no. Senator Hagan.
Yes.
Senator Hagan votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Sinclair.
No.
Representative Sinclair votes no. Representative Pugh.
No.
Representative Pugh votes no. Representative Henderson.
Yes.
Representative Henderson votes yes. Representative O'Halloran.
No.
Representative O'Halloran votes no. Senator Talbot Ross. Representative Lee.
No.
Representative Lee votes no. Representative Sato.
No.
Representative Sato votes no. Representative Babin.
Yes.
Representative Babin votes yes. Representative Caruso.
Yes.
Representative Caruso votes yes. Representative Dana. I'll recall the absentees. Senator Talbot Ross. Senator Talbot Ross is absent. Representative Dana. Representative Dana is absent. Madam Chair, I have 5 members voting in the affirmative, 7 members voting in the negative, 2 members are absent, and that is the vote of the committee.
Thank you very much. And Representative Kuhn, I'm going to turn to you first for what your report will be.
Ought not to pass.
Are the other no voters the same? So 7 ought not to pass. Thank you, everyone. And we will close the work session on LD 1230.
We're going to pivot now to some language reviews.
Is that a bird?
All right, Judiciary Committee members, we are going to start with the committee amendments to LD 2176, and I'm going to start by publicly admitting an error. You see in front of you a pink page, and as we all know, pink is final language review. This is not final language review. I was rushing around and probably wrote the wrong color. This should be yellow. So if we can all suspend our disbelief for a moment and picture yellow pages in front of us. These are the 2 amendments, the 2 versions of the amendments that we voted as a committee yesterday, both the majority committee amendment and then the minority committee amendment that was Representative O'Halloran's with a single change. What I'm going to do, and as we discussed yesterday with the preliminary. I have a couple of questions and just want to highlight some slight changes from the language you saw in front of you yesterday. The first of the changes is this new section you see right at the beginning. That was contained in the yellow amendment that you had before you. However, it wasn't drafted out. It just said add this to this section. And so this is adding it to the list of crimes, or not crimes, but adding it to the list of single acts that constitute a violation of the protection from harassment statutes, which was discussed in the amendment, but you didn't see the language to that effect. So that is what that first section looks like. If you go down to section 3 of this amendment, I reworked that section. It was a bit wordy, and so what I've done is the new lead in to that definition section. For the purposes of this section, personal information means the following information about a tenant, prospective tenant, occupant, or prospective occupant, instead of needing to, in every single place, repeat that list of people. It cleans up, making that all of that content is about any of those 4 types of individuals. And then finally, a question that I have is there was the request at the bottom of, this is now on page 2, at the bottom of the prohibition section to add fire inspector. I wanted to check with the committee. I wanted to check with the committee about whether or not, so in, my apologies, yes, thank you, Representative Purcell, in section 3, not section 2. So it's still on page 2, but section 3, the exceptions.
Just, Eli, can we hold for a second?
Yes.
We have confusion going on.
Dude, I had 2 packets when I started typing them up in the seconds. I just want to make sure that all do the same thing.
Can we wait on passing those out until we start the second one?
Sure, I'm doing 2176.
Yeah. Does everyone have in front of you LD 2176? Great. Let's
And
pause.
it just be 1, right?
Yes.
You didn't get with 2.
Correct.
1,
Yes.
Okay.
I think we're all set. Thank you.
So on page 2 of this amendment, on section 3, it's the exceptions. You had asked to add for the exception for reasonably necessary to respond to a request from a municipal code enforcement officer. You asked for the addition of fire inspector. I wanted to clarify whether or not I should also include or similar municipal officer. When looking through these, and Janet thankfully pointed this out to me, in the statutes in our Title 25, the public safety statutes that discuss fire inspectors going in, it's generally listed as fire inspector or building official. And there's some language, authority to enter buildings, for example, the building official, the fire inspector, and the municipal officers of any city or town may at all reasonable hours for the purpose of fire inspection. So I wanted to clarify, do you want just the fire inspector, or do you want to kind of cover that type of person? And so the language or similar municipal officer, I think, would get us there, if that was your intention for those members of this report.
Committee members, are you comfortable with that? Thumbs up? Okay,
Great.
great.
And then, so I guess 4 committee members on that report, and that was the majority. I apologize, I didn't write that down, though this was yesterday, so I would have assumed that we remember who was on it. All good with that one?
Yep.
Great. The second version of that amendment starts right after page 3. That is Representative O'Halloran's amendment. All of those changes in language is the same. You had requested adding authorized before occupant, and so I've circled the places in which that has been added. Otherwise, all of those changes are the same to the amendment we just reviewed.
Representative Halloran, can you put your mic on?
Is it possible just to change it to an ought not to pass, or change my vote to just a straight ought not to pass instead of?
I believe we would have to have a motion for reconsideration and then back up the vote. So it's possible to do that.
Yeah, I'd like to do that.
All right. Representative Lee, you had your hand up.
Having voted on the prevailing side, I move to reconsider.
All right. And we have a second, Representative Sato. So we'll try by a show of hands. All those in favor, this is for the, oh, yes, go ahead.
Having voted an hour ago, I'm not sure what I'm doing.
So this is a bill. Yeah, this was a bill that we worked yesterday.
Yes,
And I'm not sure if you recorded a vote on that yet.
I did, but I forgot what I did, but
Oh,
this is the ceiling bill, right?
No, no.
This is the tenant rights.
Oh, the tenant ones. Okay, I know. Yeah, okay, I'm good.
Okay. So we have a motion for reconsideration from Representative Lee, seconded by Representative Sato, and we will try by a show of hands. All those in favor of reconsideration? This is just on the reconsideration. Everyone can vote. Okay, so that appears to be unanimous of all those present. All right. Subi, are you able to pull that? The voting sheet?
We're talking about Bill 72.
Yeah, well, I guess we just need a new motion. Representative Sato.
Thank you. I would move,
That's okay. I think we're set.
Excuse me, 2176.
Thank you. Okay, Representative Sato.
I'd move ought to pass as amended with the majority committee amendments before us on the actual pink sheet that is supposed to be yellow.
Okay. Thank you. So that's made by Representative Sato. Is there a second? Representative Pugh. All right, any further committee discussion? Okay, not seeing any. I think we're ready.
Senator Carney. Representative Kuhn.
Yes.
Representative Kuhn votes yes. Senator Hagan.
No,
Senator Hagan votes no. Representative Poirier.
No.
Representative Poirier votes no. Representative Sinclair.
Yes.
Representative Sinclair votes yes. Representative Pugh.
Yes.
Representative Pugh votes yes. Representative Henderson.
No.
Representative Henderson votes no. Representative O'Halloran.
No.
Representative O'Halloran votes no. Senator Talbot Ross. Representative Lee.
Yes.
Representative Lee votes yes. Representative Sato.
Yes.
Representative Sato votes yes. Representative Babin.
No.
Excuse me, Representative Babin votes no. Representative Caruso.
No.
Representative Caruso votes no. Representative Dana. I'll recall the absentee, Senator Carney. Senator Carney is absent. Senator Talbot Ross. Senator Talbot Ross is absent. Representative Dana. Representative Dana is absent. Madam Chair, I have 5 members voting in the affirmative, 6 members voting in the negative, 3 members are absent, and that is the vote of the committee.
Thank you, Supi. So for those voting in opposition, what is your report? Not to pass? Is that the same?
Yes.
Okay.
I'm sorry, not to pass.
Correct. All right, thank you.
I'll update them.
Sort of. Yeah. One of the files I did.
Thank you.
Committee members, this was it says committee amendment. It was a unanimous committee amendment to LD. I apologize, it doesn't say it. It's LD 1444. This committee has already done final language review on this amendment. This amendment was simply cut down to stating when you last did the final language review, it stated that notwithstanding this section, the holding in the case of Finch v. US Bank NA, et cetera, may not be applied to any cause of action arising prior to January 11th, 2024. In going back and forth with the revisor's office, we really determined that instead of just saying the holding, they wanted some sort of language there describing what the holding is. And so this amendment does not change in any way the substance of what your vote was, but it is a lot more words saying the same thing. So I wanted to bring it back just to show you. This new paragraph describes the holding in a way that our statutes can alert either the attorneys or the folks in the public, et cetera, that the holding of that case is not to be applied retroactively.
That
That's
makes
all.
sense. Yep. Committee members, does that make sense? Yes? Everybody good? All right. Very good on that one.
Thank you so much. I will now turn it over to my better half, Janet.
Thank you.
It's just another attempt at a ship. Well.
Welcome, Janet. Thank you for joining us.
So this is preliminary language review for LD
Excuse me.
395, which you voted earlier this week. This would replace the text of the bill, which is about federal beneficial laws for the Wabanaki Nations, with a resolve establishing the working group to develop recommendations for extending federal beneficial laws to the Wabanaki Nations. And you asked that there be an emergency preamble. So this is what I wrote as the reasons for it to be an emergency. Also, I came up with the name of the working group, wanted to make sure that name was okay. And then the basis of this is the Tribal Task Force joint order, but had to be turned into a resolve. So you have to change some of the language. On page 2, the Tribal Task Force had 3 members of the House. This version has 2 members of the House, as you voted for it earlier this week. And I described the duties and the reporting requirement and just wanted to make sure those are all okay with you.
Representative Sato.
Thank you, Madam Chair. I'm feeling uncomfortable signing off on a language review when the sponsor of the bill is not present.
So this is a preliminary language review. We did just sign off on Senator Carney's bill a moment ago.
And I think the reason why this one is different is because this is dealing with tribal sovereignty, which I think is this very specific policy area that we deal with. And because the sponsor of this bill has spent much of her career working with the tribes to get a task force approved and get this language approved. And I just want to make sure that the sponsor also has an opportunity to sign off on it.
So this is a great point to raise, because in the past, in this committee, we only ever did a final language review, and that could have opened us up to that problem. But the Rules Committee met before the first session of this legislature and really wanted to change some procedures, because when we only meet for final language review, then all of the amendment is confidential until you finally see it. So by having a preliminary language review, this makes this language now public. And so I can now email it to Senator Talbot Ross and she can share it with whoever it needs to be shared with. And if they have issues with it, then they can then contact me and we can fix it. So I absolutely want to know if any of you have problems with this language, but if you don't, this is a mechanism to let me release it to others. Now, that's very different than the other tribal bill, which we worked on where I had specific permission to send that language. So that language has been drafted. It is now at the governor's office. All of the tribal attorneys have it, the Maine Revenue Service has it, and the Office of the Attorney General has it, because those are the folks you asked me to share it with, which is why you don't have it today, because we need to make sure it works. Because it was sort of a new idea about this rulemaking to identify pieces of land. So that is still confidential, but only with the permission to be seen by the folks you authorized me to send it to. Whereas this one was not in that category. So now I can send it to whoever needs to have it, but I wouldn't have been able to if I didn't bring it to you right now.
That seems like a great way to resolve that concern. Do you agree? Okay.
So I will email it to her, but if you all have corrections too, I absolutely want to hear.
Thank you for clarifying that for us. That's important.
Yeah, we
So committee
often
mem-
do things without explaining to you why, which is probably not wise, so I'm sorry.
So for folks who are here in the room, do you have any, I'm hoping you've had a moment to review it. Need any more time? If anyone has any comments, Representative Henderson?
Thank you, Madam Chair. The second whereas, was that in the original draft?
So this is a modification of a whereas clause that was in the original tribal task force about differing interpretations of the Maine Implementing Act. And then the differing interpretations of whether the federal beneficial laws affect or preempt was in the testimony we had on the bill. So that's why there was that notification process when a tribe thought that a federal law applied to them in 395, they would notify the state, and then there would be a response within a certain number of days of whether the state thought it didn't apply. So there was all these scaffoldings built to try and resolve those disputes. So I put that in there, but this is precisely what I'm showing you. If you're not comfortable with that language, we can take it out and just put something more generic, like to make the study happen faster. You know?
Okay, thank you for putting, you said it's from the original resolve, but it wasn't necessarily in the amendment that came before us, or it was?
So what you had before you was an outline of an idea with the task force resolve attached as the framework to build it on.
Fair. Okay, thank you.
But again, if folks don't want that in there, I'm happy to take it up.
Any other questions? All right, it looks like we're minutes. Oh, sure. Yes, let's take a couple of minutes and let people give it a careful review.
It just sounded.
It's just a language review, so. It sounds, oh, sorry, Representative Henderson.
Thank you, Madam Chair. So looking at duties on page 2 under resolved, the very last sentence, when we talk about consensus, I was understanding that consensus meant that had to be majority of legislators there as well as every single representative of the tribes. I'm not seeing that because it says consensus means consensus between representatives on the working group of the tribe or tribes affected by a particular recommendation and a majority of the legislative members of the working group. Does that specifically say that every representative of the tribe? I'm not interpreting it that way.
That's the way the language was written for the task force. I just substituted in working group for task force. So, and then it said a majority of the other members, but the only other members are legislative. So I thought that it made that specific. So I just changed task force to working group and other voting to legislative, just to be clearer. But otherwise, that's how it was written before, and that's how we interpreted it when we staffed the task force. If you want to say the agreement of all, just to be even clearer, absolutely fine with you.
And I think if that is the intent and that's how it worked before, I don't think we need to change the language. I just interpreted it. It just says consensus between representatives on the working group of the tribes. But then it specifically says the majority of legislative members. So I didn't know if
Yeah, I see it the same way.
like by not, like it just seems like, what does consensus of the tribes mean? Like, does it mean majority? I don't need to be pedantic, but it just seemed like that wasn't defined that every member of the tribe had to agree. And I thought that was what the intent from the sponsor was.
Representative Sato, did you have a comment? Okay, go ahead.
I think I see what you're reading. I think what I'm also thinking of is that what we heard in a lot of the public testimony and work sessions is that all 4 nations have different needs specifically and have different needs that they're facing. And so I think this is allowing for, if there are specific recommendations that only apply to one tribe or 2 tribes, that the consensus is of the tribes of the tribes that are specifically affected by that recommendation.
Janet's nodding her head, which is a good sign. Representative O'Halloran?
I understood it that they all wanted to have a say in everything.
Right, and it was supposed to be exactly the way that the task force was, and this language is from the task force, except that I changed task force to working group, and I changed other voting members to legislative members because there are no other voting members. So I will definitely point out in my email to Senator Talbot Ross this question though, because I think it's a good one to ask the sponsor, since it really was her idea to make it adhere.
Thank you. Representative Poirier?
Thank you. I just have a question regarding section 7 report. It's 4th line down, states that legislature having jurisdiction over judiciary matters shall report out legislation. Should that be shall or may? Because I mean,
It's usually may, but in the task force and joint order, it was shall. So I modeled it on that as I was told.
I think it should be a may, in my opinion, because having shall means we have to report it out, right?
Right, and that
Yeah,
was
that's-
required from the
Yeah.
task force joint order.
Their committee members on that point? The shall or the may? Representative Henderson?
I think, like, what's the point of the task of this working group if there's not going to be any type of report back to us? Like the whole point of it. So I think that it should be a shall, that they should absolutely report back to us so that we know what
This
their response is.
shall relates to legislation, not a report back. So this is in the second to last line of paragraph 7.
And this is one of the many reasons I brought it back, because that is an unusual feature of the task force joint order, and I was told to follow it. So I wasn't sure if you really meant that.
Representative Poirier?
I would be much more comfortable with a may, just because, I mean, we're talking about consensus issues, but if they didn't find consensus in things, the shall report out legislation is kind of like, okay, what are they gonna report out? Something that doesn't have consensus. To me, it makes more sense to have may in there. So if they're coming up with a consensus, then they may report out legislation.
Representative Crusoe, you're agreeing
Thank
with
you.
that?
I agree. I just, I think we have to let them do what they're going to do. And if they don't have a consensus or they don't have anything to propose, we shouldn't force them to do something just for the sake of doing it if they don't, there's nothing of value. So I think may gives them the authority to do it, but only if it's deemed worthy.
Representative Sato?
I think this is part of the reason why I brought up earlier about the importance of having input from the sponsor, because she was also deeply involved in the previous working group and task force on this policy area. And so I would, before weighing in my personal opinion, I would be interested in hearing what the legislative history is on using the word shall in this, because I would imagine that there is a possibility that was intentional in the original language, which would mean that there is a reason. And I'd be interested to hear that reason.
Well, I can, one of the other things I was going to tell you is we submitted a request because we are required by statute to conduct reviews of new public records, exceptions proposed in other legislation. And we were hoping to do more reviews today, but I don't have them yet. And there are definitely bills out there that by statute you are required to review. We just have not been given the requests yet. So we asked permission to meet next Tuesday and Thursday because without permission, we could not meet to do those. And we did put on there, if you give us permission, can we also do language reviews? And we did just get that back approved. So I could bring it back Tuesday. I wasn't sure if I could, because after that, all of this will have to be by email. So I feel more reassured that I'll get this processing because that's only a few words here or there. And then we can make sure whoever's here, I can't force anybody to be in the room when we do it. So.
Yeah, I'm trying to reach the bill sponsor.
I
And
believe they have several public hearings and lots of
lots
very
of
busy
things
day
going
in
on.
that.
So far, the only thing that seems remotely substantive would be this change from shall to may. And so let's see if there are other things and if there are concerns from the sponsor related to that change, we'll take it up next week. Did you want to caucus? Can you put your mic on, please?
I don't know if we should talk more about what Representative Henderson found in the second and the first okay block. If everybody's happy with that. That would be.
So if we're going to come back on Tuesday, maybe folks should really focus in on, I have 3 points: the emergency preamble language, the consensus recommendation language, and the shall or may as far as a committee bill. And just think about if this was the right way to build on the task force resolve, or if you want to have it slightly differently, which is entirely your prerogative. And then I'll put it back on the schedule for Tuesday and we'll see if we can come up with something everybody can feel really comfortable with.
That's great. So you will not process or make changes at this time. We will just.
I'm going to send it to revisor's office because I want everything in there to
Yep.
start moving before the supplemental budget hits the office.
Yep.
But I would never report it out without you seeing it again. I will
Yep.
bring it back. Whatever shape it's in, it'll probably still be preliminary. And I
Next
would
week.
never color it pink because we are too open-ended here on what we want exactly to say. And I want it to say what you want it to say.
Okay, let's plan. Is everybody comfortable with that? Giving this some thought and revisiting it? Okay, that sounds good. And we don't need to table this because it's not a matter before us. Okay.
So this next thing is just an update from a language review we did earlier this week. Again, I would bring this all back together, but I wasn't sure if we'd have permission to do language review next week when we sent out our language review email. So I wanted to at least bring this to you in person. So we did the language review for LD 2121 earlier this week, and this is a bill that was originally about trying to protect personal home addresses for certain officials in the state, and it turned into a resolve. So 3 members of the committee voted ought not to pass entirely on the bill. 9 members voted for the majority report, which was to have a working group to study the issue about how to enhance the safety of judges and elected officials in the state by removing personally identifiable information from public websites and different types of public records. And their majority report included legislators in the working group. There's also a pilot project to have up to a 2-year subscription to Delete Me or a similar type of service. For folks who qualify, you would have to opt in. And when we looked at this amendment language last time, folks were a little bit surprised because there was no fiscal note associated with having up to 2 years of a subscription for, I think, all legislators plus all judges could possibly opt in for 2 years. So it turned out that was an error. And so what you will see added to the majority report is this revised fiscal note, which still includes the cost of the legislators participating in the working group, which is why it would go to the study table if this amendment is adopted in the bodies. And then also the money that will be added in appropriation section for the cost of the pilot project. The minority report also has the same correction because it includes the same pilot project. So it will have this appropriation section added to cover the cost of that pilot project, but it doesn't require legislative resources because it doesn't have legislators or the other elected officials on the working group. So it wouldn't, if that report is accepted in the bodies, then this would not go to the study table. Because no legislative resources would be used. So this will eventually all be put together. Again, I didn't know if that would have to be done by email because I wasn't sure we could meet next week. So I at least wanted to get you the fixed numbers because everybody's eyes sort of bugged out of their heads last time. And so we got that corrected through the fiscal office. Well, maybe somebody's sitting behind me.
All right, does this amendment, does this language look good to you? And numbers? Yes, okay, great. Is that all of the language reviews?
That's all we could bring to you today. There are
Okay.
still some amendments floating out there.
Yep.
We will do them next Tuesday and Thursday.
Okay, sounds good. Committee members, I think we need to wait just a few more minutes in order to take up 1647. So let's just take a 5-minute break and I'll go check on the status of that. And please stay because we're taking our committee picture today.
Committee members, thank you for your patience during that break. We are now ready for our last work session. This is LD 1647. Eli, do you want to kick us off?
Sure. Good afternoon, committee members. LD 1647 is an act to amend the Maine Human Rights Act to provide additional remedies for educational discrimination. You will remember we last met on this bill, long ago yesterday, where you had a new yellow amendment discussing a new compensatory damages cap not to exceed $100,000. You are being passed out a new version of that same amendment. You will see in section 2, the subsection 7A, subpart B is that cap language. This amendment, though it is tough to see on the yellow, adds new language for that subpart C, stating that compensatory damages may not be awarded under this subparagraph unless the complaining party provides actual notice to the educational institution. Beyond that, I will turn it to Senator Carney to expand.
Round it out for us. Thank you, Senator Carney.
Thank you. Yes, I want to acknowledge all of the really earnest and thoughtful discussions that have brought us to this point of proposing this amendment language. There was a concern that the educational institutions really need to ensure that they have actual notice. And there were different versions of how strict and burdensome that notice requirement would be. And I think that we've agreed to this language that requires that the educational institution have actual knowledge of a complaint about discriminatory action. And so I think that we are in a place where this proposal is ready to vote. So in a nutshell, it would make available compensatory damages for intentional education discrimination, capped at $100,000. That is, there used to be uncapped damages available under federal law. Those are no longer available. And so this would give some relief to people who have been subjected to intentional education discrimination. Would also protect education institutions from uncapped liability. And it would most importantly in paragraph C drive both the students or their families and the educational institutions toward the whatever reporting and resolution process the educational institution has, so that the issue could be resolved rather than leading to litigation. So I think that's it in a nutshell. And I would ask colleagues to support it.
Are there any questions for Eli or for Senator Carney? Representative Lee.
Trying to remember, you don't have to do the notice of claim that you would have to do for the Tort Claims Act under this title. So this would be a different kind of notice altogether.
Senator Carney.
This would still be subject to the filing requirements with the Maine Human Rights Commission. And so it would go through that avenue. Which would be, I think it's 300 days to file. You have to prove that you exhausted your, you'd have to prove actual notice to the institution and that you'd exhausted your administrative requirements with the Human Rights Commission before you could bring a suit.
Yes, Representative.
My question was more because it's a governmental entity. Under the Maine Tort Claims Act, you usually have to give notice. Can't remember, it's like 100 days or something like that after the act, but this would be a different type of notice than that.
That is my understanding, but I will look into it and correct it with a floor amendment if need be.
Any further questions, committee members? Any committee discussion? The committee member like to make a motion? Oh, Representative Caruso.
Thank you. I am just trying to compare differences So there's no demonstrations of good faith or anything, all of that was taken out?
Yes, and I can explain why. So the intentional education discrimination is a term of art that is already used, and it has its own burdens of proof that the different parties have to meet. And so part of the concern about C as it was originally drafted was it was layering lots of different concepts on top of each other rather than sticking with the already applicable concept of what's required to prove intentional education discrimination.
Okay. Um. So in order to. So when you were speaking with Representative Lee, you're saying that the course of action is through the Maine Human Rights Act Commission or through the school?
Both. So what, under this language, the student or parent would have to complain, give actual notice to the educational institution. And that might be different depending on how old the student is. A kindergartner saying something to a kindergarten teacher might be considered actual notice, whereas a college student might be, actual notice maybe would be, instead of saying something to a teaching assistant in a lecture class, it would be using the reporting mechanism that is available on the college's website. I did learn that every school district in Maine has, and I'm forgetting the exact term, and I don't have my notes with me, but an affirmative action officer or something like that in order to address these disputes.
And can I ask a question to you? The bill
Sure.
sponsor?
Yes.
Go right ahead.
Okay. I don't this is just a general question. I don't understand why this is needed.
So this is needed because sometimes people are injured, have damages as a result of intentional education discrimination. And prior to last year, they could recover compensatory damages under federal law. And then there was a federal court case that said they could not recover compensatory damages. It's my understanding that that federal access to compensatory damages was not capped. This compromise legislation that's in the amendment would be a way of giving people in Maine who can prove intentional education discrimination access to limited relief if they if they give actual notice to the school and then they go through the Human Rights Commission, file with the commission, give the commission an opportunity to investigate, and then file in court.
Senator Carney, could you give us an example of what an intentional educational discrimination case, what that involves, sort of a fact pattern that might help people imagine when someone might turn to this avenue for relief?
So let's say a school has two soccer teams. And there is the girls soccer team and the boys soccer team. The girls have old equipment, 10-year-old uniforms, locker rooms that are dark and moldy. And the boys have brand new uniforms every year and locker rooms that are clean and bright and are well cared for and have been recently renovated. And the captain of the girls' team complains to the school that they're being treated unfairly with regard to the access to suitable locker rooms. And in that instance, so if say the captain complained to the person who's responsible for washing towels and returning them to athletes, that probably wouldn't be actual notice to the institution. But if the student told, for example, the principal, and the principal would probably refer them to the appropriate person at the school district level, but that would be an instance where there would be a potential allegation of intentional discrimination. And if the student, the team captain tells the principal, and the principal just says, well, it's always been that way, we're not going to change it, and doesn't take any step to investigate or remedy the disparity.
Are there other questions? Representative Caruso.
So you said that the feds used to do this, through what mechanism? Like the federal DOE, or how? I'm trying to figure, I'd like to know, like, how engaged this, how active is this like, how much is this employed, or was it employed, and through what department?
Yes, Senator Carney, if you know.
So it's my understanding, and we do have someone from the Maine Community College system here. I have had extensive conversations with folks from the University of Maine system. And also with the executive director of the Maine Human Rights Commission. It is very rare to have a litigated education discrimination claim that goes to court in Maine. There is also an avenue under federal education discrimination prevention laws. And the availability of compensatory damages was something that used to be available in the court interpretations of those federal laws. But the United States Supreme Court changed the interpretation of those federal laws. So the underlying laws didn't change, but the way the court interpreted them changed, such that when people brought intentional education discrimination claims that 5 years ago they could have gotten compensatory damages, now they cannot. And it's my understanding that it was also very rare for any federal education discrimination claim to be brought involving an institution in Maine. I think that Becky Smith from the university, I don't know if anybody in the committee room is able to provide any more detail, but my recollection from the public hearing was that these types of claims were not common. And the reason they're not common is because there is a requirement that you provide actual notice, and the schools have the mechanisms in place to receive these complaints and do something about it and resolve them.
Excuse me. Okay, please put your mic on.
Okay, so thank you for the history. When you were talking about the Maine Supreme Court that they ruled recently,
US.
Sorry, US. I was thinking US, but I said Maine. So does this proposal come into alignment with the US Supreme Court's decision, or is this to compensate for it a different way?
So this would differ from the US Supreme Court precedent in that the US Supreme Court was interpreting federal law And federal law and state law don't necessarily line up with each other in this area. But particularly with regard to damages, there is a difference between what remedies are available under state versus federal law. And so it doesn't line up, but that's not something that happens with regard to other elements of the Maine Human Rights Act, with regard to damages in particular.
Other questions? Do people need a moment or a caucus break? Representative Lee.
I think it would be, in response to Representative Caruso's question, I think it's important also to note that for the same type of discrimination in Maine, if it were to happen in the employment context, there would be compensatory damages and far more compensatory damages awarded to a plaintiff in these instances.
Yes, Senator.
Yeah, I would say I tried to stay consistent with other aspects of the Maine Human Rights Act. And so under the Maine Human Rights Act, the largest employers, the damages cap is $1 million. For the smallest employers, other than those with 14 or fewer employees, the cap is $100,000. So this cap is the commensurate with the lowest cap for employers who are subject to potential awards of compensatory damages. So it really is a limited relief that would be created.
Yes, Representative.
So, I've heard this situation that I'm about to explain as an example of something that has been an issue before. And I don't know if this law would address that or if it's being addressed in other areas. Let's say a school doesn't have like the staff or the personnel for different kinds of very specific kind of like learning disabilities or cases. They don't have anybody that can fill that need. And so the child has to be transported to a different location to receive those services. Would this cause the school to have to pay $100,000, even though they don't have the ability to provide that particular service?
So I'm not a judge and you've given very little facts. So it's a question that, to me, it sounds like if the school has found appropriate education for the student, then perhaps that is a reasonable accommodation under the law. That's how I think the people would look at that. But, you could fill in facts that would, I can't answer for all situations.
Representative Halloran.
So, I'm just curious too, like, when it comes to IEPs and things like this, if you are in a district where the school system maybe doesn't value or want to follow them as much, or they might be in a situation where they can't afford to do something that needs to be done, how would this affect that situation?
So I don't know very much. I know nothing about IEP except that I know what IEP stands for. So I don't really know much about that law. But this is really about intentional discrimination. It's not about compliance with the federal IEP law, which I understand, I believe, has its own mechanism for addressing disagreements.
Representative Sinclair.
I think this is a question for Senator Carney. I'm trying to understand the interplay between the predicate discriminatory circumstance or act and the good faith participation of the institution in their own internal administrative process to try to cure that originally identified discriminatory situation. If the school participates in good faith and trying to craft a reasonable accommodation, but later a court finds, nah, that wasn't quite reasonable, would compensatory damages still be available, or does the school's good faith participation in those processes sort of cure at least the intentionality of the underlying discrimination? And if that doesn't make sense, I'll apologize and withdraw it.
It does make sense, and I have two responses. The first is that paragraph C just requires notice to the school. But secondly, I believe that it's, the standard is, I don't think it's deliberate indifference, but it is some kind of an indifference standard that the school has to be indifferent to the student's request for accommodation, for example, before you can get into the realm of intentional discrimination.
Representative Poirier?
Thank you, Madam Chair. Is there an actual definition somewhere? What defines education discrimination? Can you point me
Senator Carney?
to where it would?
Or Eli? Eli has the answer. for us.
Title V, Section 4602 is unlawful education discrimination. There are a number of components to it. There are kind of four buckets. But unlawful educational discrimination on the basis of sex. It is unlawful educational discrimination in violation of this act on the basis of sex 2, and then it lists paragraphs of things. Unlawful education discrimination on the basis of physical or mental disability. It is unlawful education discrimination. Repeat what I just said, and then it lists paragraphs of things on the basis of national origin or race. Lists paragraphs of things, and then basis of sexual orientation lists paragraphs of things. And so there are some slight differences that are tailored to each of those different kind of categories, but that is all laid out there in that section. I can read the full out to you, or I can kind of direct. It's Title V, Section 4602.
Do people have a device to look at that, or would they prefer to get a printed copy of that? Just want to make sure you have what you need. Yes, Representative Lee.
I've been looking at it for a little while now, and the two sort of examples we heard about IEPs and folks with mental or physical disabilities. I noticed specifically in the education discrimination context that there's two kind of exceptions in 5A and 5B. So it says nothing in this section requires an educational institution to provide separate athletic or other extracurricular programs to serve a person with a physical or mental disability. And nothing in the section may be construed to affect the rights of a person with a physical or mental disability to special education programs under state or federal law. So it's sort of like, I don't know. I mean, it's kind of cabining off some of that stuff when it comes to the way we deal with special education in schools.
Yes, Senator Carney.
And I just wanted to clarify my response to Representative Sinclair. The standard is deliberate indifference.
Representative Lee, when you were stating the 5A and 5B, is that in 4602? Yes. What's the enactment date on that?
2021.
Okay, so it may be that I don't have that in front of me. My apologies. There's usually pocket parts with the new bits, but not in this copy. So I would trust the internet version more accurately than the red book.
Thank you. Other questions or discussion, committee members? Hmm. Do people need a break for a moment, or is anyone ready to make a motion to frame our discussion? Representative Crusoe?
Like a caucus.
Okay, let's take a few minutes and go caucus. All right, committee members, we're back from our break. I'm wondering if we're moving towards a motion. Would anyone like to make a motion? Representative Henderson.
I move ought not to pass.
All right. And seconded by Senator Hagan. Any further discussion, committee members? Okay, let's see, Annie. I think we're ready for a vote.
Senator Carney.
No.
Senator Carney votes no. Representative Kuhn.
No.
Representative Kuhn votes no. Senator Hagan.
Yes.
Senator Hagan votes yes. Representative Poirier.
Yes.
Representative Poirier votes yes. Representative Sinclair.
No.
Representative Sinclair votes no. Representative Pugh.
No.
Representative Pugh votes no. Representative Henderson.
Yes.
Representative Henderson votes yes. Representative O'Halloran.
No.
Representative O'Halloran votes no. Senator Talbot Ross. Representative Lee.
No.
Representative Lee votes no. Representative Sato.
No.
Representative Sato votes no. Representative Babin.
Yes.
Representative Babin votes yes. Representative Caruso.
Yes.
Representative Caruso votes yes. Representative Dana. I'll recall the absentees. Senator Talbot Ross. Senator Talbot Ross is absent. Representative Dana. Representative Dana is absent. Madam Chair, I have 5 members voting in the affirmative, 7 in the negative, 2 members are absent, and that is the vote of the committee.
All right, thank you. And for those voting in opposition to the motion, what is your report? Senator Carney?
My report would be the amendment that is the yellow document dated 3/19/26.
All right, and does that reflect everyone else's vote? Mine as well? All right, thank you. I believe that other than, oh, here, we'll close the work session. Other than our photo break, we are finished for the day. Can we have a motion to adjourn?
Sure.
All those in favor?